There are two Arkansas lawsuits over candidate eligibility that have now been decided, but they're raising new questions about who can run for public office. We learned today that Casey Reed is now disqualified from running for a state house seat in Saline and Grant counties. Missy Wardlaw, she just survived a hot check challenge in District 94. And now that Supreme Court ruling could help Pulaski County's Kristina Gulley reclaim her Justice of the Peace seat. TV11's Catherine Rowley has Gulley's fight plus legal insight on what's next.
It's of course a broad term, and it's designed to be a broad term because it comes from the state constitution. So if someone is guilty of an infamous crime, they're not allowed to hold office in Arkansas.
Legal expert and UA Little Rock professor Robert Steinbuch says the Arkansas Constitution outlines several criteria that can make a candidate ineligible to run and hold a public office.
It's a crime that impacts a person's morality, credibility, and that's why a hot check violation, a hot check offense, is precisely what should be an infamous crime.
The question this election cycle is which outcome from a hot check charge can count and which one doesn't. One candidate who faced that question was Missy Wardlaw in District 94. Her case went before the Arkansas Supreme Court. Wardlaw had a guilty bond forfeiture on her record, but the court ruled that she can keep her name on the ballot and hold a public office.
The Wardlaw case is a terrible decision, frankly. The majority decision, written by Courtney Hudson, says that Wardlaw's guilty bond forfeiture disposition doesn't mean she was convicted of that crime of a hot check offense. And it's really a stretch to understand how she gets there.
The bond forfeitures, as the Supreme Court ruled on yesterday in Ms. Wardlaw's case, those are not infamous crime convictions.
That's Kristina KG Gulley, who ran for and was elected Pulaski County Justice of the Peace for District 10. She was removed from office after being ruled ineligible for 2 hot check convictions. Gulley insists she has no convictions and has a clean record.
Considering the fact it was a bond forfeiture on mine, I'm hoping that it will open the door for a new hearing, and hopefully some things will get overturned.
The Wardlaw case now sets a new precedent. Professor Steinbuch says the Arkansas Supreme Court dissent better addresses the legal issues surrounding hot check convictions and infamous crimes.
The dissent in that case, written by Rhonda Wood, really addresses the law precisely and says, look, we have to take that record that Wardlaw doesn't dispute and read it, and it says guilty, and then the bond is forfeited.
The dissent argues that the law is clear. Guilty means guilty, whether or not there's a bond forfeiture. But the majority of justices did not agree.
The court says if you show up and say, like I said a moment ago, that you're Mr. Magoo, what? Me? Huh? I didn't know. You might get away with not being considered disqualified, even though a conviction for a hot check crime is a disqualifying event for someone running for office in the state of Arkansas.
In Little Rock, Catherine Rowley, THV 11 News.
All right, Catherine, thank you. Now, since the Supreme Court has the final say, the Wardlaw decision does create a new precedent, possibly opening the door for others to run if they paid fines before being convicted. Gulley's campaign does continue. They filed an appeal hoping to reverse her prior disqualification, but her case is still before a circuit court judge.